All right, everyone, welcome back. We are going to begin this afternoon with a panel on the anatomy of a Title IX case. Thank you so much.
Great. Thank you so much, Alyssa. Good afternoon, everyone. My name is Samantha Rogers, and I'm a staff attorney at the Sexual Assault Legal Institute, and I will be moderating today's panel on anatomy of a Title IX case. The purpose of this panel is to explore Title IX misconduct cases from the perspective of both complainants and respondents. Ms. Tiffany Watson Esquire from SALI will be speaking as an attorney who represents complainants. And for the respondent's perspective, we have Mr. Jonathan Webb Esquire from Etheridge, Quinn, Kemp, Rowan, and Hardinger. Thank you both so much for being here today, and we can get started. Tiffany, I'd like to start the first question for you for the complainant side. When a client comes to you for advice about whether to file a Title IX complaint, what do you discuss?
Well, first, I like to start with discussing their goals. If they share with me that the goal is to obtain some sort of financial award because of what they've suffered, then I will likely advise them about a lawsuit and tell them that the Title IX misconduct process is not going to achieve that goal for them. However, if they want some sort of school-based solution, then I'll advise them about the Title IX process and complaint. And if we're going to take that route, then I'll explain that it's important for them to familiarize themselves with the Title IX policy for their school. If they want to choose me as an advisor, I will thoroughly review that policy as well. And with regard to the process, I like to explain that it is a really long process, that it can sometimes feel like it's drawn out, it can be exhausting. That's not to deter the complainant, but it's just to be honest with them about enduring the time and just having to be patient, which can cause some frustration. I will explain that they'll need to participate in this process while they are doing schoolwork. And that may mean even during times where they're studying for finals. And it can be a really just challenging time to focus on your schoolwork and have to deal with this process. So I like to be really honest about that. I also explained that they have the option to not file a formal complaint, but can still get supportive measures if that's the most important thing. So if, for example, the most important thing is more time to work on schoolwork because the sexual assault incident is, traumatizing, and so more time would be helpful, then that can be something that can be put in place. Or if they are seeking to have the respondent or perpetrator moved from the class that they share with them. That can be something that can happen.
Great, thank you. And for the respondent's perspective, when a client comes to you because they think there will be a complaint against them, but they haven't received any formal notice yet, what, if anything, do you advise them?
Good afternoon. The first question I would have is why? Why are they under this impression? Once I'm able to speak with them about why, I go through the process with them, what things will look like, assuming something were to occur, assuming formal allegation were made and they receive a notice. I talk a little bit about the time frame that they're going to get into. We'll talk a little bit about the questions they may be asked. We talk a little bit about what they believe to be the allegations. And then most importantly, I get them to begin saving evidence, extrinsic evidence that they may believe is helpful, such as Snapchats are always a big issue. If they could screenshot those, if they could begin gathering text messages, if they could begin gathering email. We start the process of getting all the information we need that may be helpful ultimately once a investigator is assigned to the case.
Very interesting, thank you. And I'm curious as well, how might your advice be affected if there's a possible protective order or criminal investigation?
If there's a criminal matter, then things get a little bit more complicated, depending on what the allegations are. If it is something as serious as allegations of rape, we have a completely different conversation because all of the statements that they make will be admissible. So that would be the concern. For a protective order, potentially we have an opportunity to review what the complainant's allegations are. We would request whatever that recording is, and we have an idea of what things would look like as they proceed.
All right. And Ms. Watson, as far as the complainant side, what is your strategy for advising a client who is filing a complaint?
So when a complainant has decided that they want to file a complaint, or maybe they've come to me and they've already done so, I explain, if they haven't filed the complaint yet, I explain that a big part of it is providing a statement of what has happened. And it's important for them to understand that that statement could be used against them in comparison to other things that they've said about the incident, should the Title IX process go to a hearing. So during cross-examination, that statement could be used in comparison to another statement that they may have made during the process, like during the investigative process. So I like to advise that their statement that they provide in the complaint is as brief as possible. Just put, the necessary details about the events, the very bare minimum details. Another concern that I am sure to go over with the complainant is that you don't really want to show your hand as a complainant right off the bat. You don't want to list out every piece of evidence. You don't want to say, and I have this person who can say this and this person who can say that. For one, you don't know what that person's going to say. We'll talk about witnesses later on in this panel, but you don't control that interview. Also, you're not sure what you're going to be able to obtain as evidence yet until you speak with the investigators and what they will be looking for. So that's a very important part of what I discuss with complainants. I also explain the process as I discussed earlier, and I explained that as part of this process, the respondent will be presumed not responsible. And a lot of times that's very hard for a complainant to digest because they feel like that means that the hearing officer will start out automatically not believing them. And I just explained that that's not the case. It's a requirement under law that the hearing officer begin the process from the start with an unbiased view. So I just try to answer questions about those concerns.
And from the respondent's perspective, when the client receives notice of a complaint, what are some of your first steps and what do you look at in that notice?
Once we receive the summary and get an idea of what the allegations are, we then move over to the elements of the offense alleged, and we go through each element that is required. From there, we start talking a little bit about what my client's view is, what occurred, what allegedly occurred. After that, we again fall into extrinsic evidence that could corroborate what my client's viewpoints are.
Well, thank you. So I'm curious from both a complainant's and a respondent's perspective, and starting with Ms. Watson, what, if anything, do you see as the attorney role at the initial interview?
So at the initial interview, the attorney's role is pretty limited. So you want to spend a lot of time preparing your client. And if your client is the complainant, you want to go through actually what they're going to say during that interview when they're going to give their statement. And this is going to be the detailed statement, right? Because it's going to be included in the investigative report. And going back to the role of the attorney, one thing that an attorney will be able to do during the initial interview is pause the interview and in order to speak to their client about a specific question, a piece of evidence, or other concerns. However, you want to be sure as the attorney that you're not overusing the pause, that you're only using it in very important instances, because it can look maybe a little shady sometimes. It can look like trying to obstruct or trying to coach your client. So you want to be very strategic in the way that you use it. Let's see, many schools will say that an advisor or an attorney needs to be completely silent, and they will let you know that. You can't say, you can ask an investigator to elaborate on a question or clarify a question. You have to just sit there silent. And again, use the pause option should you need to. And just looking at my notes. Again, focusing on preparing your client very, very well for the interview, so that you can be involved as little as possible. Another thing to note during the interview is that you want to take very detailed notes as the advisor. And if you can type very quickly, you want to do it verbatim. And you want to make sure that you have the statement down word for word as accurately as you can, and who made that statement, whether it was the investigator, another investigator, or your client, because you're going to be comparing those notes to the draft investigative report. And you want to make sure that the draft of that report, when you're giving your comments and reviewing that report with your client, you want to make sure it's as accurate as you both remember it as possible, because that is going to be what, once it gets turned into the final investigative report, that's what's going to go to the hearing officer, and that's what the entire hearing is going to be based off of. So it's very important that it's accurate. I'll also note that attorneys, if a school hasn't told you that, you don't have to be completely silent, and let's say you can chime in with a question here and there, what you won't be able to do is object to a question. It's not like a deposition or anything like that. So you're not objecting. You're not saying, oh, this is an inappropriate questions. The investigators control the interview, and they ask what they want to ask. And again, you can use the pause option to advise your client accordingly.
Thank you. And Mr. Webb, do you have anything to add about the attorney's role at that initial interview stage?
I echo much of what Ms. Watson stated. Preparation is key, because you have no ability to control the interview. So what I generally do is a lot of mocks. I'm really big on mocks. I get my client statement, and then I just, after listening to it, I start jotting down notes, jotting down questions, jotting down thoughts, and I've done, I don't know, close to 50 of these. So I kind of get an idea of how interviews go and what's going to be asked and what follow-up questions, or where are there holes at. So I make sure that my clients are extremely well prepared. So we don't have to do with what Ms. Watts is warning about. We don't have to do those objections. We don't have to do those, hey, I have a bathroom break. We don't have to worry about that, because they're as prepared as possible. Obviously, things happen, but that is the key to the interview.
Mm-hmm. So what, if anything, do you both see as the attorney role during the investigation stage? And what advice would you give for representing students at this phase?
Well, for me, I want to make sure that I'm included on all of the correspondence. I want to be included on any emails from the school, any emails just related to the entire Title IX case. And so you have to rely on your clients a lot. And again, these are young people, typically, normally, who are students, who are busy with their own lives, busy with school, and may not be so quick to forward you an email or ask you, hey, did you see this email come through? Because a lot of times they're thinking, if you are an attorney, then you already know about all of this, and perhaps the school has already reached out to you. But really, it's the school communicating with the the complainant or the respondent, and you just have to make sure you're included on that. So you have to stay on top of them. You'll need to check in with your client regularly to make sure that you haven't missed anything. You want to make sure that your client is not missing deadlines. So when the process comes up to submit comments on the reports, there will be a deadline, and that is typically a hard deadline. So you want to make sure that your client is doing what needs to be done in order to submit those comments on time. You should help your client identify and gather evidence, including witnesses. And schools cannot prevent you. It's important to add that schools cannot prevent you from talking to potential witnesses. So you can reach out to a witness and say, hey, this process is going on. Your name has been given, and you will be contacted by the school. Schools cannot refuse to take evidence as long as it's relevant and legally permissible in the Title IX process. And again, like Mr. Webb stated, a lot of the evidence can come from platforms like Snapchat or Instagram, or I don't think young people are using Facebook as much as I am, but sometimes Facebook and TikTok, things like that. So you want to try to familiarize yourself with those platforms because they can hold very valuable evidence. And let's see, it's important also to understand that the witnesses that you identify yourself as the client, or that the complainant may identify, are not specifically your witness. So you don't get to control their interview. You don't get to decide what questions that witness is going to answer. You're not even going to be part of that interview for that witness. The investigator will interview that witness on their own, and your first time learning what they say is when you're reading that draft report. And so you can think that this is going to be a witness that supports your side, but sometimes they can throw you some curveballs. So you need to be prepared for that as well.
Thank you. And Mr. Webb, anything to add? What do you see as the attorney's role at this stage? Any other advice that you would give for representing students at this phase as well?
Yes, much to what Ms. Watson said, it's important for you to set regular meetings. So what I would do from the get-go is begin scheduled meetings 2 weeks from now, 4 weeks from now, 6 weeks from now. When we receive the draft investigation report, as soon as we receive it, I send out an email saying, let's discuss this via Zoom. And you don't allow that opportunity for things to fall by the wayside. You don't allow that opportunity that things exist to get lost in translation. You make sure that there is no miscommunication by setting these scheduled meetings. And as Ms. Watson said, once you get the draft investigative report, you're given a comment period. You walk your clients through that investigative report. You talk about it. You talk about potential comments. You talk about strategy as far as what to bring up, what not to bring up, what to wait for the hearing, what not to wait to the hearing. In terms of witnesses, as I mentioned in phase, you're constantly looking for these witnesses. You're constantly looking for this extrinsic evidence. You're constantly looking for support for your position. So that never stops. And I as soon as that initial interview is over, we get right into prep for the hearing, because the hearing you have, and I'm sure we're going to get into those questions, but you have very little control of once the cross-examination begins. So you want to, again, make sure that they're well prepared.
Mm-hmm. And Ms. Watson, from a complainant's perspective, I know that we've been touching on this already briefly through this discussion, but do you have anything to add as far as the process for receiving and submitting comments on a draft investigative report?
Yes, so the time period to submit those comments can feel very short, and it is in fact very short. You get about 10 days to turn around your comments on the draft investigative report. So when you receive it, you want to make sure that you're reading through it thoroughly, taking notes. You want to go through it with your client. If it's the complainant, you want to make sure that your client agrees with the way that their statements have been laid out. If there are any questions in the footnotes or any issues in the footnotes, you want to make sure that you address those with your client, and you may want to add that as a comment for the investigator to look at, or to identify for the hearing officer to pay attention to, because they will be reviewing the final investigative report. And again, this is your opportunity to compare your notes to what's in the report, and to make any corrections or additions, or provide any further explanations if they are needed. One thing to note is that the school will not work around the attorney's schedule. You can certainly ask for more time. I'm not sure that that will be granted, but there's nothing wrong with asking for more time. But you could have a situation where you've been waiting a couple months for this draft investigative report, and then it pops up for you in your inbox, and you have 10 days to turn it around, right? You could be in trial. You never know. So you can certainly ask for more time, but be prepared that you may not be given that extra time. Another thing to note is that you'll likely receive the draft investigative report in a virtual format. So it can be put into Dropbox, and you'll be able to access it and read it, but you won't be able to save it, download a copy. You can't send it to yourself. You can't type within the report. And you can't actually print the report either. It's confidential. And once that 10-day time period is up, you lose access to that. So you want to make sure you take very, very detailed notes, because you'll have a limited time to work with that report.
Absolutely understood. And from a respondent's perspective, do you have anything to add, Mr. Webb, on that process?
Yes, just briefly. It's important to note the comments often go down as footnotes. They don't really make changes to the investigative report, which again, I have to go back to my initial point why the interview is so crucial. It's the first statement. That's why I spend so much time prepping, because it doesn't have the same weight when you are relegated to a footnote of, oh, well, actually the light was green, and although up here I said it was yellow. And you know, it's presents more fodder for cross-examination. So I just want to emphasize that point. And I believe Ms. Watson handled everything else.
Interesting. All right. And Ms. Watson, from your perspective on the complainant side, what role, if any, can informal resolution mechanisms play in this process?
Informal resolutions can be very helpful for a complainant who doesn't want to be faced with going through this long drawn out investigative process. Complainant who doesn't want to go through the hearing, who doesn't want to face cross-examination, because that is a very traumatizing, difficult experience, especially for someone who has suffered sexual assault, and their life is just kind of being picked apart, and their credibility is being questioned in such a very on such a very intimate incident. It can be very difficult. So an informal resolution, for instance, if the complainant wants the respondent to just leave campus, and let's say there's been negotiations between both sides, advisors, the attorneys have been speaking as they've been advised by their clients about what they agree to, and the respondent is willing to agree to just leave campus to allow the complainant to finish their education, then that's a way to avoid this very arduous process and still get the outcome that the complainant may be looking for. But sometimes complainants, and they have every right to, they want an actual finding. And sometimes that's very important to them. They want a finding of responsibility. And so they want to go through the full process, and they have every right to. And I would advise them accordingly that that is your right, and let's do it.
Right. And from the respondent's perspective, what role do you see any informal resolution mechanisms playing, and how would you advise your clients?
Really, it's a risk analysis. I mean, you have to weigh, well, first off, let me begin with, it doesn't matter if the respondent wants an informal resolution. What matters is whether the complainant's willing to enter into an informal resolution. So if one of the parties is not willing, the process ceases and a Title IX matter goes forward as originally scheduled. So assuming that the complainant wishes for there to be an informal resolution, you have to have a conversation with your client about the risk of going to try, just like you would do in a normal criminal proceeding or any other form of litigation, the risk of going to all the way to a formal hearing. The allegations are sexual assault. You are risking having your client have a on their transcript, this individual, there are allegations that this of a Title IX violation, this individual is found in violation, and these were the sanctions. That is on this individual's transcript. They can't do anything about that at this point. And let's say, for example, they were facing expulsion. If there is a situation where my client is saying, I'd much rather go to this school anyway, and we could just enroll him or disenroll him from the school, and the Title IX matter goes away, then that may be a viable option. Again, it's just a risk analysis, a conversation you need to have with your client about what are the chances, what are their options.
Mhm. So, assuming the informal resolution process maybe isn't successful or doesn't the complainant's not interested in pursuing that route, I'm curious, starting with Ms. Watson, how would you prepare your client for a live hearing?
So, how I like to prepare is go through the report with them, and I pay particular attention because as we get closer to the hearing, we've already gone through the report a number of times, or the issues in the report a number of times, the statements, what various witnesses have said a number of times. So I like to focus on the areas that um, may not paint the complainant or my client in the best light. Let's figure that out. So I spend some time on cross-examination about what to anticipate with the questions and what kind of emotions may come up. And sometimes I'll do a mock cross-examination and dealing with those areas and focusing on those areas that are going to be difficult when the complainant is actually undergoing cross-examination. And we talk about the answers and, you know, why there may be clarification that's needed and how we can make answers stronger and, um, you know, tackling any of those issues that a respondent's attorney is really going to hammer out, right, from to show the hearing officer their point of view. We'll also work on the opening and closing statements, which is important to talk about. Those statements need to come from the client or from the complainant, in my case, because it needs to be from their voice. It shouldn't be an attorney drafting an opening and closing statement. And everyone knows what that would sound like. It would sound very legalese and all of that. But this is coming from this is a student process, and it should have a student's voice. So I will have the complainant draft an opening and closing, then I'll go through it and maybe edit, maybe organize it a different way so that it's more clear and concise. Maybe ask them to add, more words that'll make a stronger impact. But I let them lead. In that exercise. I also prepare the complainant by explaining that the hearing will be very long. It'll be a very long day. Sometimes it will be multiple days and it can be exhausting. So I prepare them for that again because I think it's important to lay out all the details and be honest with, what they might feel. And typically before the hearing, you'll have a pre-hearing meeting and you have the opportunity to meet with the hearing officer and ask very detailed questions about the hearing. Ask for clarifications, for instance, about a witness whose interview that you think may not be relevant, so you don't think they should actually participate in the hearing. You can raise those concerns at this pre-hearing meeting. I think that's all I have to add for that.
Great, thank you. And Mr. Webb, from the respondent's perspective, how might your preparation of your client be similar or different from the complainant's view?
I want my client to very much feel that they are part of this process. So we walk through every single potential witness. I ask them, let's review their statement. What questions do you have for them? What would you like me to say? What would you like me to ask them? I, of course, go through their examination. I talk to them about potential questions that they could hear from on cross. I talk to them about potential responses. We talk a little bit about the cross-examination of the complainant, and we go through that same process, much like Ms. Watson says, for potential issues that may come up if it's any potential big objection that I may have that I foresee. I would bring it up at the pre-hearing meeting, make sure we get a ruling on that beforehand. But I want my client to be very much involved with the process. We'll probably meet 4 or 5 times to talk about just different aspects of the hearing. The only matter I believe Ms. Watson didn't discuss is, so you have the opening that you can talk to your client about, and you kind of go over your theory of the case. And that's going to be one of the big things we're going to talk about, the theory that we're going to walk in with. And we go through the skeleton of the evidence that the hearing examiner is going to see, the facts that can't change that we already have memorialized as far as witness statements and things of that nature. Once that portion is over and the testimony is done, my client has a chance to summarize everything in closing. There's usually a break, 10, 15, 30 minutes for you to speak with your client and talk a little bit about, what did we just see? How did this, how can we highlight X, Y, or Z, depending on the elements that we're deciding to focus on that we don't believe the complainant was able to satisfy. After that process is over, obviously your client is an individual that gives the closing statement. You're often given an opportunity to do a victim impact statement. And that victim impact statement talks a little bit about how this entire process impacted them. And it's one of those moments where you could actually give your client the microphone to say, listen, you've been told you're a perpetrator, you've been told you're an offender throughout this entire process. How has that impacted you? How did that impact the way you go to school? How did that impact when you wanted to walk to an event and something happened? So that's the process, and we kind of talk about each and every stage.
Thank you. So are there any strategies or best practices that you'd like to share when it comes to preparing for and conducting cross-examination? Ms. Watson, if you wouldn't mind answering first.
Cross-examination in a Title IX hearing works differently than an attorney may be used to in court. You're not doing a direct examination, or there's not going to be a direct examination before you conduct your cross-examination. The direct examination is the interview that the witness has given that is in the investigative report. Now, the hearing officer will ask questions, but usually they are reflective of what has already been talked about in the investigative report. So it's like the hearing officer is asking for clarification and essentially doing a little bit, not really cross-examination, but asking for clarification. So you'll just be cross-examining every witness, actually. And so that's an important difference to point out. As far as strategies and preparing, it's all about knowing the case, just like, they teach us in law school, or teach us in evidence or trial prep, knowing the case forwards, backwards, in and out. So going through that investigative report and taking notes and preparing yourself with things that are inconsistent from other statements, things that defy common sense, things that just don't make sense when the case is looked at in totality. So you want to note those things because that's what you're going to highlight during your cross-examination.
Thank you. And Mr. Webb, anything to add as far as any strategies or best practices that you've developed from a respondent side as far as cross-examination?
I very much agree with what Ms. Watson said. Once again, what I like to do is I like to use complainants' witnesses against them in terms of their statements. Again, because this is a exercising often he said, she said, credibility is everything. So when there is an inconsistent statement, I harp on it. I want to ask question after question about it. And after I finish asking the complaining questions, I want to ask their witnesses questions. I want to ask, why do they believe the complainant said this? I want to ask questions about that actually probe into how biased some of the witnesses may or may not have been. It's because we don't, as much as I was speaking about extrinsic evidence, often when it comes to the actual act of or allegations of sexual assault, there are no other witnesses other than what the allegations are. So credibility is key. So I have to harp on inconsistent statements.
Mm-hmm. Thank you. So if we go through this hearing process, if there is a finding of responsibility at the end, what do you each view as the attorney's role in that sanctions process?
The attorney doesn't really play a role in the sanctions process. You don't get a chance to, well, just speaking from my experience as a complainant's attorney, you don't get a chance to advocate for or argue for a particular sanction. Your role is focused on the victim impact statement, helping your client or helping the complainant to draft an impact statement to really show the hearing officer how they have been affected by this sexual assault. What it, maybe laying out who they were before this incident and now who they are after it and what they anticipate needing in the future, explaining if they are in therapy and just how this whole process has really impacted them. That's what a hearing officer will actually consider when thinking about sanctions, or that's when you hope that they think about. So that's why you really need to prepare that impact statement and make it as impactful as possible. And again, it needs to be in the student's voice. That's what's most important. But you'll want to review and you'll want to edit and you want to assist them. But that's really the only role that I see an attorney playing in the sanctions process.
Mm-hmm. And Mr. Webb, what role do you see as a respondent's attorney in that sanctions process?
So once, if there is a time where we receive a finding of responsibility, we go through whether or not it makes sense to appeal. In order to appeal, you have three criteria. One is that you believe a procedural error occurred at some point in the process, that you believe that there is new evidence, or if you believe that the sanction is disproportionate with the offense. So you go through step by step to see if there was a procedural error that was committed by the hearing officer. New evidence often isn't, one of the prongs that you lean on when you're talking about appeal, but disproportionate sanction, if the allegations are stalking and the response is expulsion, those don't sound equitable, and we would attack that on an appeal.
Thank you. And speaking of appeal, Ms. Watson, what are some things that you would consider when deciding to appeal? And are there any differences in things that you would challenge on appeal?
When thinking about appealing, I will again ask, well, I shouldn't say again because I haven't touched on this. I will get a sense of how the complainant feels, basically, about what they've had to endure going through the process from beginning to end. And if they just feel exhausted by the process and just want to be done, I'm not going to push them. I'm going to let them call the shots, because I want to be trauma informed and victim centered, and I want them to direct me with, what's best for them, because I don't want to cause any more trauma, right? The process is traumatizing enough. However, if they are unhappy with the result and feel like they definitely want to appeal and they are ready, then we will talk about what the steps are to appeal. So I really kind of I take the temperature of how they're feeling. Um, I have also heard, now I haven't had this experience, but I've heard from other attorneys that sometimes they will decide to use the appeal process to point out violations in the Title IX, against Title IX or in the school's policy by the school in order to set up a civil rights claim or lawsuit. So create a record in order to begin that process. So that's also a way to use the appeal process. So we, if there's been violations that we identify, maybe we'll talk about doing something like that.
All right. And Mr. Webb, I know you've touched on this before, but as a respondent's attorney, is there anything else that you would consider when deciding to an appeal?
Other than what the client wants. What my job is to make sure that they're as informed as possible for us to go through the evidence and me to speak with them as their attorney, as the likelihood of success on appeal, and whether they wish to move forward or whether they wish to contest it. So it really depends on what my client is after.
All right. And Ms. Watson, I know on the subject of appeals, what advice would you give when responding to an appeal?
So when responding to an appeal, as the complainant, really what we're just trying to do is get the appeals board to uphold the decision. So we want to point out and argue basically in our response that the school has not made any procedural errors or anything, any sort of violation. Actually, the school did exactly what it was supposed to do, and the process went exactly as it was intended to, and that's why the decision is logical, appropriate, and it should stand. So that's basically what our response should be.
Okay. And Mr. Webb, any other advice that you would give when responding to an appeal?
It's important to take notes during the hearing, and you're going to make asterisks for yourself. And if you find that there are points that you do have that may be violations of Title IX, or they may be violations of the school's procedure, that's the appropriate time to do it. I don't have anything in addition.
Mm-hmm. Great, thank you. So something that I found interesting during this discussion is some of the differences that these Title IX panel hearings can have from traditional litigation. And I'm curious to hear from both of you, what advice would you give for advocating for your client with the school administration when you don't have any of this traditional litigation tools necessarily at your disposal? Ms. Watson, what are some of your thoughts?
Well, that's an interesting question. And my answer is probably very short, but advocating for the client in a way, probably focusing on supportive measures, I would say. So Title IX protections are in place to ensure that students have fair access to education, right? So I would seek to advocate for my client in the best way possible to get to that goal, to make sure that my client has access to education. So I would just focus on that overarching goal, advocating in any way that I could to achieve that.
Thank you. And Mr. Webb, do you have any advice?
I think it's extremely important to advocate for your client in the appropriate mediums and at the appropriate times. At this point, your client quite literally has no one else fighting for them. So it's important to make sure when you see some evidence that should not be allowed, you speak up. You shouldn't be timid about that at all. Now, when it comes to the actual hearings, you know, I one of the questions I asked during pre-hearing, is it okay for me to object? I won't state the reasons for my objection, but it's okay for me to object just to call attention to a area I see problematic. And I tend to ask for permissions such as that. But I think it's very crucial for you to advocate for your client. That is the only reason why you're there.
Thank you. I'm curious to hear from both of you as well, or what are some challenges you may have experienced or you perceive working with younger clients and students in this capacity? Ms. Watson, do you have any challenges you'd like to share?
Yes, there are challenges working with younger people. I will start by saying that I do enjoy working with students and younger people because um, they keep me young, right? And they can teach me things during the process. But it can be challenging, like I stated before, because they may not understand the seriousness of things at every juncture. So a deadline, even though they know it's a deadline, they're thinking about other things, you know? They're thinking about, am I going to go out tonight? And, you know, am I going to be with my friends, right? And I don't want to have to deal with this, even though, you know, this is a process that's important to me. I don't want to have to deal with it because sometimes they're not able to see what the consequences are down the line. And so you have to be on top of a younger client. You have to be checking in with them. I find myself feeling like, I hate to say it, but sometimes feeling like a parent, being like, hey, remember when I sent you that email? Hey, remember when I said this? I actually need you to do that, you know? So you have to just really stay on top of them. Another thing is just lack of time because this is also a student and they are, you know, hopefully really engaged with their education. And so they are busy because that is their whole point of being at school, right? Getting an education, moving on with their future, not dealing with the Title IX process, right? Nobody wants to be doing that. So they could be reluctant and, you know, just not have a lot of time. So you have to help them with that, help them find the time. Sometimes give them a schedule. I need you to, you know, look at these 8 pages today and then get back to me and let me know you did it. So it's spending a lot of time just organizing for them. That's what I find myself doing. And just recognizing their limitations and not, you know, holding anything against them because of that.
Thank you for your perspective. And Mr. Webb, are there any challenges that you've experienced or that you perceive working with younger clients and working with students in particular?
Yes, I do. Memory is huge. I cannot tell you how many times I've gone into a interview thinking that the fact pattern was one way, and it turns out there's a whole sub paragraph that we didn't even talk about that suddenly the individual remembers. So making sure that they understand how important it is to sit down for a second and write down what happened. Sit down and kind of get all of their thoughts out, like, wait, actually, chronologically, this needs to be moved over here. And so that process is important. Being forthcoming as well. Some individuals may want to skate past a detail or two, either innocently thinking it's not important or otherwise. So that's part of the process why I have so many meetings. So I make sure that they feel comfortable and understand, listen, we need to talk about everything, even the things you don't want to talk about, because that's how I prep you for cross-examination. I can't anticipate questions if you don't give me all the information. If I can't anticipate questions, I can't prep you for the hearing. And if I can't prep you for the hearing, you can walk that line on down. So memory, being forthcoming, those are the two main issues that I've seen.
Very interesting indeed to hear both of your perspectives on working with students, younger clients. And I think in that same vein, and speaking of working with students and younger clients, Ms. Watson, what do you think is or should be the role of the parent for student clients?
The role of the parent should just be supportive. Um, I approach these cases as not only an attorney, but an advocate. And so I want to make sure I'm advocating for what the student wants at the end of the day, always. And so I want to make sure that parents understand that that's my role. And that's what I hope that they will also recognize the need to step back in certain instances. And I understand the concern from parents, but I just try to impress upon them that the student needs your support. Um, and please, if you can, don't try to direct them. And I certainly, when we're having confidential conversations and I'm advising my client and things, parents not in there. So when I am meeting with parents, because the student has said they would like me to meet with the parents, I'm explaining they just need your support. However, I've had an instance where a parent was a witness. So in that case, the parent was part of the case, and I had to have a separate conversation and things like that with the parent. But generally, I would just try to guide them into being as supportive as possible, but and letting the student take the lead.
Thank you for your perspective. And Mr. Webb, what say you? What do you think is or should be the role of the parent for student clients in this process?
Often it depends on with your client and the parent. Those are conversations you have to have without the parent in the room. You have to gauge their level of being comfortable with the parent in the room. Most often, individuals are not likely to talk about certain things because of their parent. Let's say, for example, if alcohol was involved, their parent doesn't know that they drink, so they're going to skip over that detail during these meetings. Or let's say marijuana or anything else is involved. They may be hesitant to say. So those are things you need to gauge at the beginning, and those are private conversations you must have with your client. I agree with Ms. Watson. Parents should, if your client is willing, they should be in a support role. That's fine. But as they are in a support role, they're often in every single one of these meetings. So again, it just depends on what your client wants and what makes them comfortable.
Great, thank you so much. Well, that concludes the questions that I have for today's panel. Thank you, Ms. Watson, and thank you, Mr. Webb, so much for participating. This was a very interesting discussion. I'd like to open very briefly if anyone had any other questions we'd like to pose for our panelists while they're here briefly. I also see that Alyssa has put in the chat an anonymous evaluation form for this panel. We ask that all participants please fill out. If there are any questions briefly in the chat, we'd be happy to take at this time. Otherwise, again, thank you very much, Mr. Webb and Ms. Watson, for participating in today's panel. This was, I found at least, extremely interesting to hear both sides of this Title IX case.
Thank you. Thank you, everyone.
Appreciate it.